Good morning, everybody. Does the government have the authority to regulate things affecting health and safety in the workplace? Well, that question was addressed on this date, April 17, in 1905, when the Supreme Court ruled in Lochner versus New York. The Fifth and 14th Amendments contain the clause, "Person shall not be deprived of life, liberty, or property without the due process of law." But what does due process have to do with the workplace? Well, that's our topic. So here's New York City, late 1800s, super crowded. Same could be said for other big urban areas in our country. And a lot of people lived in tenements. Tenements were pretty small, made of wood, everybody crowded together. And a lot of these tenements had little businesses in them, including bakeries. So bakeries need ventilation, they need lots of running water, they need a way to get rid of your waste, and a lot of these tenement bakeries didn't have any of that. In fact, people sometimes had animals in the bakery, so that bread that you're buying might have animal fur or animal hair in it. But really got people nervous was the heat put out by the ovens in these bakeries that were all crowded together, and many of them were in wooden buildings. The risk of fire was really high. So in 1895, New York State passed the Bake Shop Act, modeled on one in Britain, and it set minimum standards for how much you would work, 10 hours per day or 60 hours per week, and it had other regulations like that. So Joseph Lochner was a baker up in Utica, upstate New York, and he was fined for violating the Bake Shop Act. Some of his people worked more than 60 hours a week. And he was found guilty, and he appealed, and it went all the way to the Supremes, and the lawyers for Lochner argued that this was not fair, discriminated, because it didn't apply to all bakers, like those in hotels, for example. Lochner's lawyers also said that this didn't fall under the police powers of the state because no one's health, safety, or welfare was threatened. Nobody got hurt in the bakery. And they said, this is really about hours. You're really just limiting the time we can work, and you just tacked on the health and safety later. So the lawyers for New York State said it's all about health. And this is clearly within the jurisdiction of the government. And this is really what this case is all about. So on this date, April 17 in 1905, the Supremes ruled in Lochner versus New York that Lochner was correct. And their reasoning was that contract law, the arrangement between a worker and an owner, is protected by the Due Process Clause of the Fifth and 14th Amendments, especially the 14th Amendment. And the vote was 5-4 in favor of Lochner, and the 4 dissenters said this has nothing to do with the 14th Amendment. Plus, workplace safety is definitely in the jurisdiction of the government. So this cartoon makes fun of the fact that it doesn't look like the Supreme Court cares about your health. And then the guy on the right says, boy, that seems pretty half-baked. But this idea of contract law as being protected by the Due Process Clause carried on. In 1923, for instance, the Supreme Court said that minimum wage laws were unconstitutional because they violated the right of contract. But by the time we get to 1937, the Supremes changed their minds, and minimum wage, for instance, is allowed. And it's pretty clear by now that this contract law is not sacred, and it's really not connected to the 14th Amendment. So in our country, we believe in laissez-faire economics, where it's a free market and minimal government interference. But on the other hand, we realize that we have to have workplace safety. So in this balance between profit and safety, Another example of the drama in a capitalistic economy.